Before we begin, a quick and important disclaimer. This presentation is for informational and educational purposes only. I am not a financial advisor, attorney, or housing counselor. The information provided in this video does not constitute legal or financial advice. Every situation is unique, and the laws vary significantly by state. Please consult with qualified professionals for advice tailored to your specific circumstances. It starts with a knot in your stomach. Maybe it was a layoff at work, an unexpected medical bill, or a business that just dried up. For the first time ever, you look at your mortgage payment and you know you can't make it. A week goes by. Then two. Your phone starts ringing with a number you don't recognize. You ignore it. Then an envelope arrives. Doesn't look like a normal bill. Feels heavier. You open it, and you see words like delinquent, accelerate, and the one that makes your heart stop, foreclosure. In that moment, you feel completely and utterly alone. But you are not. Right now, hundreds of thousands of American families are in this exact position. And the single biggest mistake almost all of them make isn't missing that first payment. The biggest mistake is what they do next. Nothing. They hide. They hope it goes away. They let fear paralyze them. And that silence is the most expensive mistake you can possibly make. This video is your antidote to that fear. We are going to pull back the curtain on the entire mortgage default and foreclosure process in the United States. We're not just going to talk about what happens, we're going to give you a step-by-step chronological roadmap of what the bank is doing, what they're legally required to do, and most importantly, what your options are at every single stage. By the end of this, you will understand this process better than 99% of homeowners. You will replace panic with a plan. So let's start with the most misunderstood word in this entire ordeal. Default. What does it actually mean? Most people think if you miss one payment by one day, you're in default and the foreclosure army is about to kick down your door. That is completely false. Missing a payment doesn't instantly put you in default. It makes you delinquent. Think of it like this: being delinquent is like getting a C on a test. It's a warning sign. Your lender will start charging late fees, usually after a grace period of about 15 days, and your credit score will take a hit. They'll start calling and sending letters to remind you that you're behind. This is the annoyance phase. But legally, you're just late. Default is when the situation officially escalates. It's when your lender formally recognizes that the terms of your loan agreement, your mortgage contract, have been broken. So when does this happen? There's no single magic number of days that applies to every loan in the country. But a general rule of thumb is that most lenders will consider a loan to be in default after you have missed 3 consecutive payments, or are 90 days past due. Some may even wait until 120 days. This is the first critical piece of information you need to understand. You have time. The system, believe it or not, has built-in windows of opportunity. The bank doesn't actually want to take your house. Foreclosure is an expensive, messy, and time-consuming legal process for them. They would much rather have you paying your mortgage. So, in those first 30, 60, and 90 days of delinquency, they are primarily focused on one thing: contacting you to figure out what's going on. This is why hiding is so destructive. By not communicating, you're signaling to them that you're not willing to work on a solution, forcing them to move to the next, more serious step. And that next step is what we're here to talk about. Once you cross that 90-day threshold and officially enter default, a new clock starts ticking. This isn't just the bank's internal clock anymore. This is a legal clock, governed by a complex web of federal and state laws. The lender's friendly reminder calls stop, and the formal legal letters begin. The first of these you'll likely receive is called a breach letter, or a notice of intent to accelerate. This document is a game changer. It's the bank's official warning shot. It says in very clear legal terms, you have broken the contract. You have a certain amount of time, typically 30 days, to fix this problem, to cure the default, by paying the full amount you owe, including all the late fees. The letter will also state what will happen if you don't cure the default. And this is where that scary word comes in: acceleration. Accelerating the loan doesn't mean they charge you more interest. It means they demand the entire remaining balance of your mortgage be paid immediately. All of it. If you owe $300,000 on your house, they are saying you now owe them $300,000 due right now. This is the legal mechanism that allows them to then initiate the foreclosure lawsuit, because you, like 99.9% of people, cannot write a check for the full value of your home on the spot. Receiving this letter is terrifying. But again, it is not the end. It is a formal step in a long process. It is a warning. Federal regulations, specifically from the Consumer Financial Protection Bureau, or CFPB, actually prohibit a lender from making the first official foreclosure filing in court until you are more than 120 days delinquent. Let me repeat that because it is absolutely crucial. In most cases, the bank legally cannot even start the foreclosure process until you are 4 months behind on your payments. That's 4 months from the first missed payment. For months where you can be proactive. For months where you can explore options. For months to build a strategy. During this 120-day pre-foreclosure period, your lender is also required by law to provide you with information about your options to avoid foreclosure. They have to tell you about programs that might help you, like loan modifications, forbearance plans, or repayment agreements. They must assign a specific person or a dedicated team to your case, someone you can talk to directly to get information and explore those options. This isn't the bank being nice. It's the law. These protections were put in place after the 2008 financial crisis to prevent the very chaos that so many people fear. So let's recap where we are. You've missed several payments. You've gone from delinquent to being in default. You've received the intimidating breach letter. And the bank has threatened to accelerate your loan. The 120-day pre-foreclosure window is now closing. You're standing on the edge of a cliff. The bank has done its legal due diligence. They've sent the warnings. They've assigned a contact person. If you haven't been able to cure the default or work out an alternative solution, the bank is now ready to take the single most aggressive step in this entire process. They are about to file a lawsuit and officially begin the foreclosure. This is where things get public, where the courts get involved, and where the fight to save your home truly begins. What happens the day they file that lawsuit? How are you notified? And what are the first critical moves you absolutely must make to defend yourself? That's where this story goes next. The day the lawsuit is filed, the game changes. All the letters, all the phone calls, all the threats from the loss mitigation department, that was the preamble. This is the main event. In a quiet, sterile county clerk's office, a lawyer representing your lender, who you've likely never met or spoken to, hands a stack of papers to a clerk. A file is created, a case number is assigned, and a stamp is slammed down. Just like that, you are no longer just a homeowner who is behind on payments. You are now a defendant in a civil action. The state is now officially involved, and your home has become the subject of a legal battle. But you don't know this yet. You're at work, making dinner, helping the kids with homework. The first you'll hear of it is when a stranger comes to your door. This is called service of process, and it is one of the most jarring, unnerving moments in this entire ordeal. It's a constitutional requirement. You have a right to be officially notified that you're being sued, and they take it seriously. Most often, it's a county sheriff's deputy or a private process server. They will walk up to your front door, knock, and ask for you by name. When you confirm it's you, they will hand you the stack of papers. They won't explain it. They won't offer advice. Their only job is to hand you the documents and sign an affidavit swearing to the court that they did so. That's it. The interaction is cold, clinical, and terrifying. You're standing in your doorway, holding a thick packet of legalese that represents the single greatest threat to your family's stability, and the person who delivered it is already walking back to their car. What if you're not home? They'll try again and again. If they can't find you, they might be allowed to use substituted service. This means they can leave the lawsuit with any adult living in the home, a spouse, a roommate, even a child over a certain age. Imagine your teenage son or daughter opening the door to a sheriff who hands them a lawsuit against you. Or what if you're avoiding them? What if you see them coming and refuse to answer the door? They might just tape the lawsuit to your front door and mail a copy to you. In some extreme cases, if they can prove to a judge they've tried everything and can't find you, they can get permission to serve you by publication. By printing a tiny legal notice in a local newspaper you probably don't even read. The point is, they will notify you one way or another. Ignoring the knock on the door will not make it go away. So now you have the documents. You close the door, your heart is pounding, and you look down at this packet. What is it? You'll see two main documents, the summons and the complaint. Let's start with the summons. This is the most important time-sensitive piece of paper in the entire stack. The summons is not a suggestion. It is a command from the court. It will say in very clear terms, you are being sued. And then it will deliver the most critical piece of information you will receive in this entire process, the deadline. It will say you have a specific number of days to file a formal, written response with the court. In most states, this is just 20 or 30 days from the day you were handed those papers. 20 days. That is not a lot of time. This deadline is a ticking time bomb. If you let it expire, you lose. It's that simple. It is the first and most important trap you must avoid. Next is the complaint. This is the bank's story. It's a numbered list of allegations, their version of the facts. It will read like a simple, brutal narrative. Paragraph 1. On this date, you signed a promissory note, promising to pay us back. Paragraph 2. To secure that note, you also signed a mortgage, giving us a lien on your property. Paragraph 3. Here is a copy of the note and mortgage. Paragraph 4. We are the current owner of your loan and have the right to enforce it. Paragraph 5. You stopped paying on this date. Paragraph 6. You are in default. Paragraph 7. We have met all the legal requirements to foreclose. And then the final, devastating conclusion. Wherefore, the plaintiff demands judgment, foreclosure of the mortgage, the sale of the property to the highest bidder, and that you and all occupants be removed from the property. Reading this is a punch to the gut. Feels final. Feels official. The bank has laid out its case in black and white, and on the surface it all seems true. You did sign the papers. You did fall behind. It's a natural human reaction to feel a sense of hopelessness, of shame, of defeat. And right here at this exact moment, you arrive at the single most important fork in the road of this entire journey. It is a decision that will determine everything that comes next. You have two choices. You can do nothing, or you can fight back. Let's talk about what 90% of people do. They do nothing. They put the papers on the kitchen counter. They feel overwhelmed. They don't understand the legal language. They don't have money for a lawyer. They think, the bank is right, what's the point? So they let the 20-day deadline come and go. This is, without a doubt, the most catastrophic mistake you can make. Because the moment that deadline expires, the bank's lawyer files a simple motion with the court. It's called a motion for default judgment. They tell the judge, Your Honor, we served the defendant with the lawsuit. The law gave them 20 days to respond. They have not responded. They have waived their right to defend themselves. Therefore, everything we said in our complaint must be accepted as 100% true. And the judge, in most cases, will agree. The judge will sign an order. A judgment of foreclosure is entered against you. You have been found guilty without a trial. The fight is over before it even began. The next notice you get in the mail will be the date your house is being sold at auction. By ignoring the lawsuit, you hand the bank a swift, easy, and total victory. But there is another path. The path of resistance. And it all starts with one document, your answer. An answer is your formal, legal response to the bank's complaint. It is your voice in the court. It is you standing up and saying, not so fast. Filing an answer within that 20 or 30-day deadline completely changes the entire dynamic of the case. It stops the default judgment dead in its tracks. It signals to the bank and to the court that you are not going to roll over. You are going to fight. So what does an answer look like? Surprisingly simple. You go through the bank's complaint, paragraph by paragraph, number by number. For each allegation, you have 3 possible responses: admit, deny, or state that you lack sufficient knowledge to either admit or deny. Some things you'll admit. Admit, I live at this address. Admit, I signed a mortgage on this date. But the real power comes from 2 words. I deny. You might be thinking, how can I deny that I signed the promissory note? Or that I'm behind on payments? That would be lying. But this is where the legal strategy begins. Think about paragraph 4 of their complaint, the one that says, we are the current owner of your loan and have the right to enforce it. Do you know for a fact that this is true? Your original loan was likely sold by your original lender moments after you signed it. It was then bundled into a mortgage-backed security, sold to investors on Wall Street, and transferred dozens of times between different banks, trusts, and servicers. The company suing you right now might just be a servicer who gets paid to collect payments, but they might not legally own the debt. Do they have the original, physical, wet ink signature promissory note in their possession? Because in many courts, if they don't have that original note, they lack the legal standing to foreclose. They are like a person suing you over a car crash when they weren't even in the car. So when you respond to that paragraph, you can, in good faith, say deny. You are not denying you have a loan. You are denying that they, the specific company suing you, have the legal right to take your home. You are forcing them to prove it. And you would be shocked at how often they can't. Decades of sloppy, fraudulent paperwork, of robo-signing, of lost documents in a complex chain of transfers. This is the soft underbelly of the banking industry. By filing an answer and denying their standing, you are taking your first real shot at their biggest weakness. This single act transforms the case from a 30-day sprint for the bank into a long, drawn-out marathon that could take months or even years to resolve. It buys you the most valuable asset you can have in this situation: time. Time to negotiate a modification, time to find a new job, time to save money, time to plan your next move. The summons and complaint is not an eviction notice. It's not a final judgment. It is an invitation to a fight. And by filing your answer, you are accepting that invitation. You are stepping into the ring. You have survived the first round. But now the bank knows you're a fighter. They can't win by knockout anymore. They have to win on points. This means they have to start building their case, and you have to start building yours. The next phase of this war is called discovery, and it's where you get the legal right to demand answers from the bank. What documents are they hiding? What mistakes have they made? And how can you use their own internal records against them to save your home? This is the moment the entire game changes. Because discovery isn't just a legal procedure, it's a declaration of war. It's you, the homeowner, turning the tables and putting the bank, the multi-billion-dollar institution that's been sending you threatening letters, on the witness stand. And you have three primary weapons in your arsenal. First, you have what are called interrogatories. Think of this as a legal interrogation. You get to draft a list of specific pointed questions that the bank is legally required to answer, in writing and under oath. Questions like, identify every single person who has handled my account since its inception, state the exact amount you claim is owed, and provide a detailed breakdown of every single fee, charge, and penalty included in that amount. On what date did you physically take possession of the original promissory note for my loan? They can't dodge. They can't ignore you. They must answer, and their answers become sworn testimony in court. Your second weapon is the request for production of documents. This is your search warrant. You are no longer asking politely. You are legally demanding that they open their vaults and hand over their files. Every single document related to your loan, the original mortgage contract, the promissory note, the actual physical piece of paper with your wet ink signature on it, the complete transaction history from day one, all correspondence between you and the bank, including internal notes and call logs you've never seen, every letter they sent you, every single transfer of your mortgage from one bank to another, a document trail called the chain of title. You're not just looking for a piece of paper. You're looking for the cracks. You're hunting for the mistake, the broken link, the one thing they can't produce. And that leads to your third and most surgical weapon, requests for admission. These are devastatingly simple. You write a series of statements, and the bank must either admit or deny them. For example, admit that you are not in physical possession of the original promissory note. Admit that you charged a late fee on a payment that was received on time. Admit that you failed to provide notice of the assignment of the mortgage as required by law. If they admit it, that fact is now considered proven for the rest of the case. It's locked in. If they deny something you can later prove is true, you've just caught them in a lie before a judge. It's a legal trap, and it is incredibly powerful. So what are you actually hunting for in this mountain of paperwork? You're searching for the bank's original sin. And the most common, the most catastrophic for the bank, is a concept called standing. It's a simple idea. To sue someone, you have to be the one who was actually harmed. To foreclose on a house, you have to be the party that actually owns the debt. You have to prove you have the right to be in that courtroom. And how do they prove it? They have to produce the original promissory note endorsed over to them. This sounds simple, but you have to understand the chaos of the modern mortgage market. Your loan wasn't just sitting in a file cabinet at your local bank. It was likely bundled with thousands of other mortgages, chopped up into tiny pieces, and sold as a complex financial product called a mortgage-backed security to investors all over the world. This process, called securitization, created a paperwork nightmare. The original notes were supposed to be transferred perfectly at each step, from bank to trust. But in the rush to make billions during the housing boom, corners were cut, documents were lost, endorsements were forged or never happened at all. An entire entity, MERS, the Mortgage Electronic Registration System, was created to try and track all of this digitally, acting as a placeholder owner for the banks. But it often made the problem worse, creating a tangled mess where no one could prove who owned what. So when you demand the bank produce the note, you're not just asking for a document. You are challenging their very right to take your home. You're saying, prove it. Prove you actually own this debt and didn't lose the paperwork in a multi-trillion-dollar shell game. And you would be shocked at how often they can't. They show up with a photocopy, a digital scan, an affidavit from some vice president who has never seen the note but swears it exists. In many courts, that's not good enough. No original note, no foreclosure. Game over. But the hunt doesn't stop there. You're also looking for evidence of one of the biggest financial scandals of the 21st century: robo-signing. During the foreclosure crisis, banks were so overwhelmed with foreclosures that they set up assembly lines. Low-level employees with no legal training and no knowledge of the cases would sit in a room and sign tens of thousands of legal affidavits a month, swearing that they had personally reviewed the loan documents and that all the information was accurate. They hadn't. They were just signing their names, sometimes using fake titles like Vice President of Foreclosures, for 8 hours a day. It was fraud on an industrial scale. Through discovery, you can demand to know who signed the affidavit in your case. You can demand to see their employment records, their job description. You can even take their deposition and ask them under oath. Did you personally review my payment history? Did you personally verify the amount owed? Or were you just signing a stack of papers someone put on your desk? Uncovering robo-signing can get a case thrown out of court instantly. Then you dig into the numbers, the loan history they send you. You become a forensic accountant. And you start to find the mistakes. You see a payment you made on the 5th of the month that they didn't credit until the 15th, triggering a late fee. You see property inspection fees of $75 charged every 2 weeks, even though no one ever came to your house. You see the most predatory charge of all: force-placed insurance. This is when the bank claims you let your homeowner's insurance lapse, so they buy a new policy for you, from a company they often have a relationship with, at a price that is 5 or 10 times the normal rate, and they add that massive cost to your loan balance. They stack these phantom fees on top of your loan, and then, through clever and often illegal accounting, they apply your regular monthly payment to these fees first, before applying it to your interest and principal. So even though you're sending in your full payment every month, their books show that you're constantly falling behind on the actual mortgage, because your money is being eaten by fees you don't even know exist. This creates a default out of thin air. It's a manufactured crisis. And without discovery, you would never have the proof. But with their own internal accounting records in your hand, you can walk into court and show the judge exactly how they cooked the books. Finally, you're looking for violations of federal law. Laws like RESPA and TILA, the Truth in Lending Act, put strict rules on mortgage servicers. When you apply for a loan modification, they have a specific time frame to respond. They have to give you a single point of contact. They cannot engage in what's called dual tracking, the illegal practice of negotiating a loan modification with you with one hand, while moving ahead with the foreclosure sale with the other. They tell you on the phone, "Don't worry, we're working on your application, just send us one more document," while their lawyers are simultaneously filing motions to sell your house at auction. It's cruel and it's illegal. And discovery is how you get the proof. You demand their internal call logs. You demand the emails between the modification department and the foreclosure department. You find the evidence of their lies, and you use their own words to show a judge that they have been acting in bad faith. This is the turning point. You are no longer just a defendant in a lawsuit. You are the plaintiff in your own investigation. You're not just defending, you're attacking. Every document they can't find, every fee they can't justify, every law they broke, every signature that was forged, it all becomes ammunition. This evidence doesn't just help you defend the foreclosure. It gives you leverage, gives you power. You can now file your own claims against the bank for fraud, for breach of contract, for violating federal statutes. Suddenly, the bank isn't just trying to collect a debt. They're facing the risk of having to pay you damages. The entire dynamic of the case has been flipped upside down. So now you've done it. You've weathered the initial storm, you've filed your answer, and you've conducted discovery. You have a mountain of evidence, a pile of the bank's own documents that show their case is weak, fraudulent, or built on a foundation of lies. The question is, what do you do with it? How do you transform this raw intelligence into a weapon that can actually win the war? This is the moment the entire dynamic shifts. You are no longer David standing before Goliath with just a sling. You are David, and you've just found Goliath's secret battle plans, detailing his every weakness, his every vulnerability, written in his own hand. This pile of paper is no longer just evidence. It's leverage. It's power. It's the key that can unlock the steel trap that has been closing around your life. But a key is useless if you don't know which lock to turn. A weapon is just a piece of metal until you know how to wield it. The first step isn't to run to the courthouse and throw the papers at the judge. That's amateur hour. The first step is to become a surgeon. You and your attorney lay every single document out, not on an operating table but on a war room table. You are looking for the fatal flaw. Not just any error, but the one undeniable catastrophic mistake that unravels their entire case. Maybe it's a document signed by Linda Green. Remember her? The infamous robo-signer. A so-called vice president for 20 different banks, who later admitted in a deposition that she signed tens of thousands of foreclosure documents a month without ever reading them, without any knowledge of the loans, sometimes just scribbling a name she could barely read. Finding her signature on your paperwork isn't just a clerical error. It's proof that the affidavit attesting to the validity of your debt is a complete fabrication, a fraud upon the court. Or maybe you trace the ownership of your loan, the so-called chain of title. Your mortgage was supposed to be transferred from lender A to trust B to servicer C. But the documents show it went from A to Z, then back to B. The chain is broken. The entity suing you has no more legal right to foreclose on your home than your next-door neighbor does. They don't own the debt. They are a stranger to the transaction, a ghost with a lawsuit. You've just proven they have no standing to sue. This is the analysis phase. You're not just reading words. You're hunting for contradictions. You're cross-referencing dates, signatures, and notary stamps. You're looking for the impossible. The document notarized in Florida on a day the signer was proven to be in Texas. The assignment of mortgage that was dated and signed after the foreclosure lawsuit was filed. A legal impossibility, like trying to get insurance on your car after you've already crashed it. Once you've found this kill shot, this single undeniable point of failure, you weaponize it. This isn't done with shouting or anger. It's done with the cold, calculated precision of legal writing. Your attorney will draft what's called a motion to dismiss, or a motion for summary judgment. Think of this document not as a plea, but as a formal accusation. It is a legal cruise missile, programmed with the coordinates of the bank's weakness, and aimed directly at the heart of their case. The motion tells a story. It begins by laying out the undisputed facts, using the bank's own documents as exhibits. Exhibit A, the affidavit signed by Linda Green. Exhibit B, a copy of Ms. Green's deposition in a separate case where she admits to being a robo-signer. It methodically builds a logical argument, citing legal precedent and statutes, that leads to a single inescapable conclusion. The bank's case is fundamentally flawed and must be thrown out of court. The day that motion is filed is the day the bank's lawyers stop seeing you as a case number and start seeing you as a problem. Their entire business model is built on volume and speed. They file thousands of foreclosures assuming 99% of homeowners will either do nothing or give up. They budget a few hours of a junior attorney's time for each case. It's a foreclosure factory. But you just threw a steel crowbar into the gears of their assembly line. Suddenly, their simple, profitable foreclosure is a quagmire. They have to respond to your motion. That means a senior partner, someone who bills at $1,000 an hour, has to sit down and read every word you've written. They have to try and find a way to explain away the evidence, their own evidence. They have to explain to a judge why a fraudulent document should be considered valid. They have to explain how they have the right to foreclose when their own paperwork shows they don't own the loan. The frantic phone calls begin. The junior attorney calls the senior partner. The senior partner calls the in-house counsel at the bank. They are no longer on offense, they are on defense. And this is just the beginning, because now you press the attack. You launch the next phase, discovery. If the motion was a targeted missile strike, discovery is a full-scale ground invasion of their territory. The term sounds gentle, discovery, as if you're just looking around. That is not what it is. It is a legal interrogation under penalty of perjury. First, you send interrogatories. These are written questions that the bank is legally obligated to answer under oath. You don't ask, "Are you committing fraud?" You ask questions they cannot evade. Please identify the name, title, and job description of the individual who signed Exhibit A. Please state the precise date and physical location where they signed it. Please describe in detail the process by which this individual personally verified the accuracy of the information contained in the affidavit before signing. Then, you send a request for production of documents. You demand to see the original wet ink promissory note. Not a copy, not a digital scan, the actual piece of paper you signed at closing. In the chaos of the 2008 crisis, these original notes were bundled, sold, and resold so many times that they were often lost. And the law in many states is crystal clear. No original note, no foreclosure. It's like trying to sell a car without the title. They are legally required to produce it, and if they can't, their case can crumble. But the most powerful weapon in the discovery arsenal is the deposition. This is where the real drama happens. Your attorney gets to sit the bank's representative, the person who signed your foreclosure documents, in a conference room with a court reporter transcribing every word, and question them for hours. Under oath. Imagine the scene. The so-called vice president, who in reality is a low-level office worker from a processing center in a different state, is now sitting under the harsh fluorescent lights of a lawyer's office. Your attorney slides a copy of the affidavit they signed across the table. Is this your signature? Yes. And this document states you have personal knowledge of the facts of this case. Is that correct? Yes. Okay. Please tell me the outstanding principal balance on this loan. Without looking at the document. They can't. Please tell me the original date of the mortgage. They can't. Can you describe the process by which you personally reviewed the payment history for this specific loan to check for accuracy? How long did that review take? They squirm. They deflect. They say they don't recall. Because the truth is they never looked at it. They just signed a stack of papers put in front of them that day. Your lawyer is now getting all of this on the record. Every "I don't know," every "I don't recall," is another nail in the coffin of the bank's credibility. What you are doing is systematically dismantling the bank's case, piece by piece, using their own employees and their own documents. You are forcing them to spend a fortune in legal fees to defend a case they thought would be a slam dunk. The cost-benefit analysis that drove them to foreclose in the first place is now turned completely upside down. It is now cheaper for them to deal with you than to fight you. You have made yourself too expensive to defeat. The bank is now facing a terrifying choice. They can continue to fight, risk a public humiliation in court where a judge might rule that their practices are fraudulent, and potentially set a legal precedent that could affect thousands of their other cases. Or, they can try to make this problem go away. The phone rings. It's their lead counsel. They're no longer sending threats. They're no longer making demands. They want to talk. They want to make a deal. The war isn't over, but the balance of power has fundamentally, and perhaps permanently, changed. This is how the game is played. For months you are nothing. A number on a spreadsheet. A liability. An annoyance. You receive letters generated by a machine, making threats drafted by lawyers who have never seen your face or heard your name. You are an insect to be crushed under the heel of an institution so vast, it registers your existence only as a statistical probability of default. But the moment you find that one single crack in their armor, that one misplaced document, that one procedural error, that one fatal flaw in their chain of title, everything changes. The machine grinds to a halt. A human being has to pick up the phone. And that human being is a very expensive lawyer, whose time is now being spent not on foreclosing, but on negotiating. The initial conversation isn't an apology. It's not an admission of guilt. It's a carefully worded, professional probing. The bank's counsel speaks in measured tones, the arrogance replaced with a kind of weary pragmatism. They talk about resolving the matter and finding a mutually agreeable path forward. These are code words. What they mean is, we've run the numbers. The cost of fighting you in court, and the non-zero chance that we might actually lose, has now exceeded the cost of just giving you what you want. So let's talk. The first offer they slide across the table is almost always the same. It's called a loan modification. On the surface it looks like a lifeline. They'll say, look, we see you've had some trouble. We're willing to work with you. They might offer to lower the interest rate for a few years. They might offer to extend the term of the loan from 30 years to 40. Which lowers the monthly payment but means you'll pay them tens of thousands more in interest over the long run. Or they might offer to take the payments you've missed and tack them onto the end of the loan. They'll call this a trial modification. You have to make 3 or 4 on-time payments at this new lower amount. You have to submit a mountain of paperwork, pay stubs, tax returns, bank statements, a hardship letter detailing every ounce of your financial misery. You do all this, you jump through every hoop, you bleed on the page for them. And then at the end of the trial period they can still turn around and say, sorry, you don't qualify. And in the meantime, while you were in that trial period, the foreclosure clock was still ticking. For many people it's a trap. It's a way for the bank to look reasonable to a judge while continuing the foreclosure process behind the scenes. If the modification doesn't work, they might offer something called a short sale. This is where they agree to let you sell your house for less than you owe on the mortgage. Say you owe $300,000, but the house is now only worth $220,000. They'll let you sell it for $220,000, and if you're lucky, they'll forgive the remaining $80,000 difference. You lose your home, but you get to walk away without the bank chasing you for that deficiency. It's a devastating outcome, but for some, it's better than the foreclosure auction. Then there's the deed in lieu of foreclosure. This is the quiet surrender. You literally hand them the keys. You sign a document that gives the deed to your house directly to the bank. In exchange, they agree to cancel the foreclosure. Again, you lose your home. The dream is over. But it's a slightly less brutal scar on your credit report than a full-blown foreclosure. They call it cash for keys. Sometimes they'll even give you a couple $1,000s to move out quickly and leave the place in decent condition. It's a purely economic decision for them. It's cheaper than paying an eviction lawyer and cleaning up a trashed house. These are the options for the powerless. These are the crumbs the bank offers when they have you cornered. But our homeowner, the one with the lawyer who did their homework, is not powerless. They are not cornered. They hold the one card that terrifies the bank. The possibility that the bank's claim to their home is built on a foundation of sand. So when the bank's lawyer offers a standard modification, our homeowner's lawyer doesn't just say no. They laugh. They lay out their terms. This isn't a negotiation between equals. This is a hostage negotiation. And the bank's multi-billion-dollar asset portfolio is the hostage. The first demand is a principal reduction, not a temporary interest rate cut, not a longer term, a permanent, immediate reduction of the total amount owed. They say, this house is now worth $220,000. That is what the new loan balance will be. You are going to write off the other $80,000 of ghost equity that vanished in the crash. You will eat that loss because your shoddy paperwork put you in this position. The second demand is a fixed interest rate, not a teaser rate that balloons in 2 years. A new 30-year fixed rate loan at the current market rate. No tricks, no adjustments. The third demand, the bank pays all legal fees. The homeowner didn't ask for this fight. They were defending their home against a flawed and potentially illegal foreclosure. The party that created the error will be the party that pays to fix it. And the final, most important demand. All of this will be memorialized in a permanent, legally binding loan modification agreement. Not a trial period. A done deal. The bank's lawyer on the other end of the phone is silent for a moment. This isn't just asking for a deal. This is dictating the terms of surrender. Why would a bank, an entity with skyscrapers in its name, even entertain this? Because of 3 things: cost, risk, and precedent. The cost is simple math. How many hours will their in-house and outside counsel have to build to fight this in court? Discovery, depositions, motions, hearings. Could easily run into the tens, even hundreds of thousands of dollars. A principal reduction of $80,000, which for the bank is just a paper write-down, can suddenly look a lot cheaper than a prolonged legal war. The risk is catastrophic. What if they go to court and the judge agrees with the homeowner? What if the judge says, you failed to produce the note? You failed to prove ownership. You have no standing to foreclose. In the best-case scenario for the bank, the case is dismissed and they have to start all over again, costing them years and a fortune in legal fees. In the worst-case scenario, the homeowner's dream scenario, the judge could rule that the lien on the property is void. The debt is unsecured. The homeowner gets to keep the house, potentially free and clear. It's a legal long shot, a Hail Mary, but it's a risk that no bank's legal department ever wants to take. A 1 in a million chance of losing $300,000 is a risk they can't afford. And then there's precedent. This is the one that keeps the bank's executives up at night. If they lose this fight publicly, if a story runs in the local paper about a family who beat the bank because of a paperwork error, it becomes a contagion. Every single person in foreclosure will hire a lawyer and start demanding to see the note. It would open the floodgates. It's far, far better for them to quietly settle this one case, make this one homeowner whole, and bury the entire affair under a non-disclosure agreement. They're not just settling a lawsuit, they're containing an outbreak. So the dance begins. The bank comes back with a counteroffer. We can't do a principal reduction, but we can offer a 10-year interest-only period. The homeowner's lawyer says no. The bank comes back a week later. Okay, a $20,000 principal reduction and a lower interest rate. The lawyer says no. My client's position is unchanged. This is a war of attrition. It's about who can hold their nerve longer. The homeowner is fighting for their family's future. The bank is fighting for a number on a balance sheet. The lawyer knows who is more motivated. Weeks turn into a month. Then one Tuesday afternoon an email arrives. It's from the bank's counsel. Attached is a settlement proposal. The homeowner and their lawyer read it together. A principal reduction to the current market value. A new 30-year fixed loan at 4%. All late fees and penalties waived. A provision for the bank to pay $10,000 in legal fees. It's everything they asked for. It's victory. The relief is overwhelming, a physical weight lifted from their shoulders. They saved their home. They beat the giant. But the lawyer holds up a hand. The war is won, yes. But the peace treaty has yet to be signed. And the bank's lawyers didn't get to their corner offices by being careless. The most dangerous traps are never in the open field of battle. They're hidden in the fine print of the surrender. This is where the illusion of freedom shatters. You see, losing the house feels like the end. Feels like the ultimate price has been paid. The bank took the collateral, the very thing the loan was for. In any sane world, that should be the end of the transaction. You give back the keys, they keep the house, and everyone walks away, bruised but whole. But we are not in a sane world. We are in the world of finance, governed by contracts written in a language of pure, unadulterated liability. That fine print, buried deep in the hundreds of pages you signed at closing, contains a clause that is the legal equivalent of a landmine. It's called a deficiency clause. And it's the reason the war isn't over. A deficiency is the ghost of your mortgage. It's the phantom debt that can rise from the grave of your foreclosure and haunt you for years, sometimes even decades. Here's how it works in brutally simple terms. Let's say you owed $300,000 on your mortgage when the bank foreclosed. The bank, now the proud owner of your former home, doesn't want to be a landlord. They want cash. So they put the house up for a foreclosure auction. Now, these auctions are not like the ones you see on TV. They are grim, hurried affairs, often held on the courthouse steps. The buyers are typically professional investors looking for a steep discount. They're not paying market value. So your $300,000 home might sell for just $200,000. The bank got the house and they got $200,000 in cash. But your original loan was for $300,000. That means there is still a $100,000 shortfall. That gap, that missing $100,000, is the deficiency. And according to that contract you signed, you are still personally liable for it. The house is gone. The dream is gone. But $100,000 of the debt remains. An unsecured, free-floating obligation with your name written all over it. You might think, so what? My credit is already destroyed. I have no assets. What can they possibly do? This is the single most dangerous assumption a former homeowner can make. Because the bank has one more weapon in its arsenal. It's called a deficiency judgment. After the foreclosure sale is complete, the bank's lawyers can march right back into court and file a new lawsuit against you. Not to take your house, they already did that. This new lawsuit is to get a court order, a legal judgment that says you owe them the deficiency amount. And a judgment is not just an IOU. It is a legal superweapon. It transforms that phantom debt into a tangible, enforceable monster. It gives the bank the legal right to forcibly collect that $100,000 from you in ways that can dismantle your new life before it even begins. Imagine this. It's been a year since the foreclosure. It was the worst year of your life, but you're a survivor. You found a small apartment. You landed a new job, nothing glamorous, but it pays the bills. You're slowly, painfully putting the pieces back together. You're starting to sleep through the night again. Then one evening there's a knock on the door. A man in a cheap suit hands you an envelope. You've been served. Your old mortgage lender is suing you for $100,000 plus interest, plus their attorney's fees. The floor drops out from under you. You thought it was over. You thought you had paid the price. But the bank has come back for more. If they win that lawsuit, and they almost always do because the math is simple and the contract is clear, the judge will grant them a deficiency judgment. With that piece of paper, the bank becomes one of the most powerful creditors you can imagine. They can now petition the court for a writ of garnishment. This means they can send a legal order directly to your new employer, requiring them to deduct a percentage of your paycheck, often up to 25%, and send it directly to the bank before you ever see a dime. Your new salary, your lifeline, is suddenly being siphoned off to pay for a house you no longer own. They can also get a bank levy. This allows them to freeze your bank accounts, checking, savings, everything. They can literally reach in and take whatever money is there, up to the amount you owe. The rent money you just deposited? Gone. The cash you were saving for a car repair? Gone. They can drain you dry without warning. And it gets worse. A deficiency judgment acts as a lien. This means it can attach to any other property you own or might own in the future. If you somehow manage to save up and buy another piece of property, even a small plot of land, that judgment will be waiting. You won't be able to sell or refinance it without paying off the bank first. It follows you. It's a permanent cloud over any attempt to rebuild your wealth. It's a financial ball and chain that you will drag with you everywhere you go. Now, at this point, you're probably thinking this is the most terrifying, unfair system imaginable. And you're right. But there is a critical piece of the puzzle that changes everything. And it's one of the most important things you will ever learn about American real estate law. The bank's ability to pursue a deficiency judgment depends entirely on one thing: which state you live in. The United States is not one country when it comes to foreclosure law. It's 50 different countries. Each state has its own set of rules, and they fall into two broad categories: recourse states and non-recourse states. In a recourse state, the lender has full recourse to come after you personally for the deficiency. States like Florida, New York, and Texas are recourse states. In these places, the deficiency judgment is a very real and common threat. The bank can and often will pursue you for the shortfall. It's the Wild West of collections. But then there are the non-recourse states. In these states, the law provides a shield for the homeowner. The law essentially says that the house itself is the only collateral. If the bank forecloses, they can take the house, but that's it. They have no further recourse against you for the deficiency, at least on your primary residence for the original purchase loan. The debt dies with the foreclosure. States like California, Arizona, and Minnesota have strong anti-deficiency laws. Living in one of these states can be the difference between a fresh start and a decade of financial servitude. But even this isn't simple. The exceptions can swallow the rule. For example, in many non-recourse states, the protection only applies to the original mortgage you took out to buy the house. If you ever refinanced and took cash out, that cash out portion might be considered a recourse loan, and they can sue you for that part. The protection also might not apply to second mortgages, home equity lines of credit, or investment properties. It's a legal minefield, deliberately designed to be confusing. The bank is counting on your confusion. They are counting on your fear. So you're standing in your apartment holding that court summons, and the first thing you have to figure out is what kind of battlefield you're on. Are you in a state that gives your enemy an arsenal of weapons, or one that hands you a shield? The answer to that question will determine your next move, your strategy, and your chances of survival. Because the bank has filed the papers. Their lawyers are billing by the hour. The clock is now ticking on a judgment that could cripple you for the next 20 years. The peace treaty was a lie. The war has just entered a new, more personal, and far more dangerous phase. The fight is no longer for your home. It's for your future. This judgment is not a bill. It's not a polite request for payment. It's a court-ordered license for the lender to hunt you. They have been granted the legal authority to reach into every corner of your financial life and take what they claim is theirs. And they will do it with a chilling and personal efficiency that the regular debt collection industry can only dream of. The weapon they wield is called a deficiency judgment, and it's one of the most powerful tools in the entire financial system. The name itself sounds deceptively simple. Deficiency. It's the shortfall. It's the difference between the total amount you owed on your mortgage, including all the penalties, late fees, and legal costs they piled on, and the price your home fetched at the foreclosure auction. Let's be very clear about that auction. It's not a retail sale. Your home wasn't listed with a realtor who staged it beautifully and held open houses to get the best possible price. It was sold on the courthouse steps, often in a cash-only auction, to a handful of professional investors looking for a deep discount. The bank itself is frequently the only bidder, and they might buy it back for a fraction of its market value. So let's say you owed $300,000. The house in a normal market might be worth $280,000, but at the foreclosure auction, the bank buys it back for $150,000. You've lost the house, you've lost every dollar of equity you ever had, and now the court says you still owe the bank $150,000, plus interest, plus their attorney's fees for suing you to get the judgment in the first place. That is the deficiency. It's a phantom debt, born from a fire sale you had no control over, and it will now follow you like a shadow. Armed with this judgment, the creditor, who is now officially a judgment creditor, transforms. They are no longer just a bank. They are an extension of the court's power. And they have three primary weapons to deploy against you. The first and most common is wage garnishment. This is the financial equivalent of a direct assault. They don't have to ask you for the money. They don't have to call you. They file another piece of paper with the court, which then issues an order directly to your employer. Your HR department is now legally obligated to become the bank's collection agent. Before you ever see your paycheck, they will slice off a piece of it and send it directly to your creditor. The amount they can take varies by state, but federal law allows for up to 25% of your disposable earnings. Think about that. Not 25% of what's left after you pay your rent and buy groceries. 25% of your take-home pay gone. Vanished. One day you're bringing home $4,000 a month struggling but making it work. The next, $1,000 is simply gone. Redirected to a debt on a house you haven't lived in for a year. How do you pay rent? How do you afford gas to get to the very job they're garnishing? This isn't a one-time hit. It happens every single payday. Every week, every 2 weeks, for years on end, a portion of your labor is confiscated to pay for a ghost. The second weapon is the bank levy, also known as a bank account garnishment. If wage garnishment is a direct assault, the bank levy is an ambush. It is swift, silent, and devastating. The creditor, armed with their judgment, can locate any bank account that has your name on it. Checking, savings, even a joint account you might share with a spouse or a child. They file a writ of execution, and the bank is legally ordered to freeze your account. One morning you'll wake up, try to pay a bill online, and see your balance is zero. Or you'll be at the grocery store checkout, your cart full, and your debit card is declined. You call the bank in a panic and they deliver the news. Your account has been levied. All the money in it, up to the full amount of the judgment, has been seized and sent to the creditor. The rent check you just wrote is going to bounce. The car payment you scheduled is going to fail. Your world is thrown into absolute chaos in an instant, without a single word of warning. They don't have to tell you it's coming. They just do it. They drain your financial lifeblood in a single move, leaving you stranded. The third weapon is the property lien. This is the long-term siege. A judgment creditor can place a lien on any other real estate you own. Maybe you have a small vacant lot you inherited, or a partial interest in a family cabin. The lien attaches to that property's title like a barnacle. You can't sell it. You can't refinance it. You can't do anything with that asset without paying off the judgment creditor first. It just sits there, a legal anchor chained to your name, preventing you from moving forward. And these liens aren't just for property you own now. In many states, they can attach to property you acquire in the future. So if you spend the next 10 years trying to rebuild and you finally save up enough to buy another small home, that old lien can suddenly appear and attach to your new property, pulling the past right into your present. These three weapons, wage garnishment, bank levy, and property lien, create a state of constant financial anxiety. You live in fear of your own success. A new job with a higher salary? That just means they can garnish more. An inheritance from a loved one? That just means a bank account they can levy. You are forced to live in a cash-only world, looking over your shoulder, always waiting for the other shoe to drop. The psychological toll is immense. It's a 20-year sentence of financial paranoia. But here is where the battlefield gets complicated, and where a sliver of hope begins to emerge. The rules of this war are not the same everywhere. The United States is not one country when it comes to deficiency judgments. It's 50 different kingdoms with their own sets of laws. This is, without a doubt, the single most important variable in your post-foreclosure life. You live in either a recourse state or a non-recourse state. In a recourse state, the lender has full recourse to come after you personally for the deficiency. States like Florida, New York, and Pennsylvania are recourse states. This is the danger zone, where everything we've just described is a daily reality for thousands of people. The lender is allowed, and often encouraged, to pursue you for the shortfall. But then there are the non-recourse states. In these states, the law provides a shield. The legislature has made a decision that if a lender makes a loan secured by a piece of property, then the property itself is the only thing they can take to satisfy the debt. The debt is non-recourse to you personally. If they foreclose, they take the house, and that's the end of it. The story is over. They cannot sue you for a deficiency judgment. States like California, Arizona, and Minnesota have strong anti-deficiency laws, creating a safe harbor for homeowners. The foreclosure is still painful, your credit is still damaged, but you are protected from the horror of being hunted for decades to come. Understanding which type of state you live in is like knowing whether you have a shield or you're standing in the open. But even in the most aggressive recourse states, the fight isn't automatically over. The creditor still has to follow the rules perfectly. They have to properly sue you for the deficiency, which means they have to properly serve you with the lawsuit. If you've moved and they can't find you, they might not be able to get the judgment. Furthermore, some states have very short statutes of limitation for filing a deficiency suit, sometimes as little as 90 days after the foreclosure sale. If the bank misses that window, their opportunity is gone forever. And in some cases, you can even challenge the judgment itself by arguing that the foreclosure sale price was grossly inadequate, that the bank essentially cheated by buying the house for a ridiculously low price just to inflate the deficiency. So you see, the judgment is not an absolute end. It's a powerful weapon, yes, but it has weaknesses. The system has rules, and those rules can be used against the creditor just as they can be used against you. They have laid siege to your finances, but every siege can be broken. Every predator has a weakness. The question is no longer just how you survive their attack, but how you launch a counteroffensive. The path forward isn't about hiding. It's about understanding the law, identifying the cracks in the creditor's armor, and finding the leverage you need to dismantle that 20-year sentence, piece by painful piece. This is where the game changes. The creditor, whether it's the original bank or a debt buyer who purchased your old mortgage for pennies on the dollar, is counting on you to be exhausted, demoralized, and uninformed. They expect you to see that massive number on the court summons and simply surrender. They are betting on your despair. We are going to bet on their sloppiness. The first crack in their armor, and often the widest, is procedural error. The foreclosure and the subsequent lawsuit for a deficiency are not simple matters. They are highly regulated, multi-step legal processes with dozens of rules that must be followed to the letter. And in the high-volume assembly line world of debt collection, corners get cut. Mistakes are made. Your first line of attack is to become an auditor of their every move. Did they serve you with the lawsuit correctly? There are strict state laws about how a summons must be delivered. Was it handed to you personally? Left with an adult at your residence? Or was it just taped to the door of your old empty house? An improper service of process can, in some cases, get the entire lawsuit thrown out before it even begins. You can't be judged in a case you were never properly notified of. Next, you unleash the most feared phrase in a debt collector's vocabulary: prove it. Under the law, the entity suing you must prove two fundamental things. One, that they have the legal right to collect the debt, and two, that the amount they claim you owe is accurate. This is the produce the note strategy on steroids. If your debt was sold, they must provide a perfect, unbroken chain of title, called an assignment, showing how the debt traveled from your original lender to them. Any gap, any missing signature, any shoddy paperwork, and their legal standing to sue you evaporates. You challenge them to produce every single document, every assignment, every record. You are looking for the one missing link that breaks their chain of ownership. Simultaneously, you scrutinize their behavior. The Fair Debt Collection Practices Act, or FDCPA, is your shield. Did they harass you with endless phone calls? Call you at unreasonable hours? Discuss your debt with your family or your boss? Misrepresent the amount you owe? Threaten you with actions they can't legally take, like having you arrested? Each violation of the FDCPA is not just a complaint. It's a potential counterclaim. You can sue them back. This is legal Aikido, using the force of their own illegal aggression to throw them off balance. Suddenly, you're not just the defendant. You're the plaintiff. The hunter becomes the hunted. This gives you incredible leverage in any negotiation. But let's say their paperwork is perfect and their conduct has been flawless. Their case seems ironclad. It's not. We now move to the heart of their claim, the number itself. That terrifying $50, $100, or $200,000 figure they claim you owe. This number is not sacred. It is a calculation, and calculations can be wrong. Your job is to deconstruct it line by line. The entire basis for a deficiency judgment is the difference between what you owed and the price the home fetched at the foreclosure auction. But was that auction price fair? Foreclosure auctions are notorious for fire sale prices. A home worth $300,000 might be sold for $150,000 to a single savvy investor who showed up that day. Many states require the sale to be commercially reasonable. You can argue it wasn't. This is where you fight back with data. You hire an independent appraiser to determine what the fair market value of your home was at the time of the sale. You pull comparable sales, comps, of similar homes in your neighborhood that sold around the same time. If you can show a judge that the bank sold your 4-bedroom colonial for a fraction of its true value, you can argue that the deficiency amount should be based on the fair market value, not the artificially low auction price. If the court agrees a $75,000 deficiency could be reduced to $10,000 or even to zero, then you attack the other side of the ledger, the total debt they claim you owed. You must demand a full itemized accounting of the debt. Don't accept a single number. You want to see every charge, every fee, every penalty that was added to your original loan balance. And you will question everything. Look for duplicated charges. Look for exorbitant legal fees from the foreclosure. Were you charged for forced place insurance at a ridiculously high rate after your own policy lapsed? Were late fees calculated correctly according to your original loan documents? Banks and servicers often load up these accounts with what are called junk fees. They are counting on you never to question them. You will. You will challenge every penny that isn't clearly and legally justified by your mortgage agreement. $1,000 here, $500 there, it adds up, eroding their claim and strengthening your position. Even if all of that fails, there is one final, absolute defense that can act as a legal time bomb, wiping out their claim entirely: the statute of limitations. Every state has a law that sets a strict deadline for how long a creditor has to sue you for a deficiency judgment. This time limit can be anywhere from 3 months to 10 years or more, depending on the state. The clock usually starts ticking from the date of the foreclosure sale. If the creditor waits too long and files their lawsuit even one day after the statute of limitations has expired, their case is dead on arrival. It doesn't matter if the debt is valid. It doesn't matter if they have perfect paperwork. The law says they are too late. You would be amazed how often a debt buyer purchases an old debt, sits on it for a few years, and then tries to sue, completely unaware that the legal window has slammed shut. A simple motion to dismiss based on an expired statute of limitations can end the entire nightmare, instantly and permanently. By now you see the pattern. You are not a passive victim. You are an active adversary, creating problems for the creditor at every turn. You challenge their right to sue, you challenge their conduct, you challenge the sale price, you challenge their accounting, and you challenge their timing. You are making this lawsuit as difficult, as expensive, and as risky for them as possible. And that is the entire point. Because in the vast majority of cases, the goal isn't necessarily a dramatic courtroom victory. The goal is leverage. The goal is to create so much doubt, so much work, and so much potential legal risk for the creditor that they become desperate to make the problem go away. This is when the settlement offers start to appear. Once they realize you are not the easy target they expected, that you have a defense and you're willing to fight, their entire calculation changes. A lawsuit that might cost them tens of thousands in legal fees to pursue, with no guarantee of winning, suddenly looks like a bad investment. They would rather get a small guaranteed amount of money from you now than risk getting nothing later. This is where you can negotiate to settle that massive $50,000 deficiency for $10,000, $5,000, or sometimes even less, paid either as a lump sum or in a manageable payment plan. You've taken their 20-year sentence and bargained it down to a manageable fine. You have survived the fall. But this raises a terrifying question. What if you can't fight? What if you don't have the resources, the evidence is stacked against you, or you simply lose the case and are now saddled with an ironclad judgment you absolutely cannot pay? What happens when the legal system has rendered its final verdict, and the bill is due? For many, this is the true bottom. This is the point where all the strategies and counteroffensives have failed. There is, however, one final nuclear option, an escape hatch built into the foundation of American law, for precisely this kind of unsurvivable financial catastrophe. And understanding how and when to use it is the last piece of the puzzle. This escape hatch is called bankruptcy, and for most people, the word itself feels like a branding iron of failure. It's a word whispered in shame, a last resort for the irresponsible. But that's a fundamental misunderstanding of what it is and why it exists. Bankruptcy isn't just a white flag of surrender. It's a strategic tool, a constitutional right woven into the fabric of American law, designed to provide a fresh start when the alternative is financial ruin. It's the system's pressure release valve, acknowledging that sometimes, for some people, the debt becomes an inescapable prison. And when a foreclosure is the final wall closing in, bankruptcy is the legal equivalent of a shaped charge, capable of blowing a hole right through it. But it's not a simple tool. It's complex, with devastating consequences of its own. For a homeowner facing foreclosure, this path splits into two main roads, Chapter 7 and Chapter 13. Understanding the difference is everything. Think of Chapter 7 as a financial fire sale. It's also known as liquidation bankruptcy. The court appoints a trustee who gathers up all of your non-exempt assets, things the law doesn't protect, sells them, and uses the money to pay off your creditors. Whatever dischargeable debt is left over after that sale is wiped away. Gone. It's the faster, more absolute path to a clean slate. For your credit card debt, your medical bills, your personal loans, it's a financial reset button. But what about your house? That's where the word exempt becomes the most important word in your vocabulary. Every state has what's called a homestead exemption, a law that protects a certain amount of the equity in your primary residence from creditors. The problem is, these exemption amounts vary wildly. In some states it's a pittance, maybe $20,000 or $30,000. In others it's unlimited. If the equity you have in your home, the value of the home minus what you owe on the mortgage, is more than your state's exemption, the trustee can and will sell your house. They'll give you the exempt amount in cash and use the rest to pay your debts. So, for a homeowner with significant equity, Chapter 7 is a gamble that could easily end with you losing the very thing you're trying to save. Then there's Chapter 13. This isn't a fire sale. It's a forced reorganization. Think of it as a court-mandated payment plan. Instead of liquidating your assets, you work with the court to create a plan to repay a portion of your debts over a 3 to 5 year period. You make one consolidated payment to the trustee each month, and they distribute it to your creditors according to the plan. It's a longer, more disciplined process. But for a homeowner fighting foreclosure, it has a superpower that Chapter 7 lacks. It provides a clear legal path to keep your home. It allows you to take all the mortgage payments you've missed, the arrearage, and spread them out over the life of the plan. So you resume your regular monthly mortgage payment, plus a piece of what you owe from the past. As long as you make those payments, the lender cannot foreclose. Chapter 13 forces their hand, giving you the breathing room to catch up that they refused to give you before. But regardless of which chapter you choose, the moment you file for bankruptcy, its single most powerful feature kicks in. It's called the automatic stay. The instant your petition hits the court's filing system, a legal injunction, a massive invisible stop sign, is slammed down in front of all of your creditors. It's not a request. It's an order backed by the full force of the federal judiciary. All collection activities must cease immediately. The harassing phone calls have to stop. The wage garnishments are frozen. And most importantly, the foreclosure sale is halted. If your home was scheduled to be auctioned off tomorrow at 10 a.m., and you file for bankruptcy today, that auction cannot legally proceed. The automatic stay is an emergency brake on a runaway financial train. It gives you immediate, invaluable breathing room to figure out your next move. This is the critical junction. With the foreclosure frozen by the automatic stay, you now have to use the bankruptcy process to solve the underlying problem. If you file Chapter 13, you begin the process of proposing that repayment plan to cure the default. You're essentially telling the bank, the foreclosure is off. Here is how I am legally going to make you whole over the next 5 years. If you file Chapter 7, the stay is only temporary. It stops the immediate sale, but it doesn't provide a way to pay back the missed payments. The mortgage lender will quickly file a motion with the court asking to lift the stay, arguing that you have no way to get current. And often the court will grant it, allowing the foreclosure to pick up right where it left off. The main benefit of Chapter 7 in a foreclosure scenario is often to wipe out all your other debts, the credit cards, the car loans, to free up enough monthly cash flow to be able to afford the mortgage again, and then try to negotiate a solution with the lender from that stronger position. But let's be brutally honest. Declaring bankruptcy is financial chemotherapy. It might save you from the cancer of foreclosure, but the treatment itself will wreck you. The immediate impact on your credit score is catastrophic. It's not a ding, it's a crater. A bankruptcy filing can drop a good credit score by 200 points or more, practically overnight. That filing stays on your credit report for 10 years for a Chapter 7, and 7 years for a Chapter 13. For years, you will be radioactive to lenders. Getting a new car loan, a credit card, and especially another mortgage will become monumentally difficult, if not impossible. The interest rates you're offered, if you're offered any at all, will be punishingly high. It's also not free. You have to pay court filing fees, and more importantly, you need a good bankruptcy attorney, which can cost thousands of dollars. Trying to navigate this process alone is like trying to perform surgery on yourself using a YouTube tutorial. And it's public. Bankruptcy filings are public records. Anyone, a future employer, a landlord, a nosy neighbor, can look it up. Finally, you lose control. A court-appointed trustee will scrutinize every aspect of your financial life. Your budget, your spending, your assets, it's all subject to their approval. It is a humbling, often humiliating process. So, bankruptcy is not an easy way out. It's a calculated, strategic decision to amputate a part of your financial life to save the rest. It's for when the numbers no longer add up, when the deficiency judgment you're facing is so massive it would cripple you for life, or when the weight of all your debts combined makes keeping the house a mathematical impossibility without a full reset. It is the absolute last line of defense. It's a powerful shield that can stop a foreclosure cold, but it's also a bomb that you detonate at the center of your own financial world, and you will spend the next decade rebuilding from the blast zone. Making that choice and living with its aftermath is the final brutal chapter of the foreclosure story. So what does that blast zone actually look like? The first thing you'll discover is that the world operates on a currency you no longer have: trust. And the primary measure of that trust is your credit score. A foreclosure doesn't just lower your score, craters it. We're talking a drop of 100 to 160 points or even more. If you had a 780 score, you could easily find yourself in the low 600s overnight. If you were already in the 600s, you're now in subprime territory, a financial leper colony. This number, this single three-digit score, will now dictate the terms of your life for years to come. The first, most immediate crisis is housing. You've just lost your home, and now you need to find a new one. But nearly every landlord, every property management company, runs a credit check. They'll see the foreclosure, a giant, flashing red light that screams high risk. To them, you are the tenant who couldn't pay the single most important bill in their life. Why would they trust you to pay rent? You'll face immediate rejections. If you do find a landlord willing to take a chance, they'll demand a premium, a much higher security deposit, maybe 2 or 3 months rent up front. They might require a co-signer, forcing you into the humiliating position of asking a friend or family member to financially guarantee your life. You'll be competing for apartments against people with clean records, and you will almost always lose. Your choices will be limited to the least desirable properties, the ones that can't afford to be picky. But the housing crisis is just the beginning. The shockwaves from your credit score's collapse will ripple through every aspect of your existence. Need a car to get to work? Forget about a decent loan. If you get approved at all, it will be at a predatory interest rate, the kind that ensures you pay for the car twice over. Your car insurance rates will go up, because studies have shown a correlation between low credit scores and higher claims. The insurance company sees you not just as a financial risk, but a physical one. Need to set up utilities in your new expensive rental? The power company, the gas company, the internet provider, they'll all check your credit. And they'll likely demand a hefty security deposit just to turn on the lights. Credit cards? Your existing cards may have their limits slashed or be closed altogether. Applying for a new one will be a fruitless exercise. Your only option will be a secured credit card, where you have to give the bank your own money, say $500, to hold as collateral. In return, they give you a card with a $500 limit. You are essentially borrowing your own money back from them at interest, just for the privilege of demonstrating you can make a payment on time. Even your career can be impacted. More and more employers, especially in the financial sector or for positions that handle money, run credit checks as part of their background screening. A foreclosure can be seen as a sign of irresponsibility or desperation, making you a potential liability. It could be the silent reason you don't get the job, a black mark you can't explain away. For 7 years, that foreclosure will remain on your credit report. 7 years of being treated like a second-class financial citizen. 7 years of paying more for everything, of being denied opportunities, of having to explain and justify the worst financial moment of your life, over and over again. But the story doesn't even end there. For many, there is a ghost that haunts them long after the house is gone. It's called a deficiency judgment. Remember that the foreclosure auction is meant to pay back the bank. But what if the house sells for less than what you owed? If you owed $300,000, but the house, in its distressed state, only sells for $220,000, there's an $80,000 shortfall. That's the deficiency. In many states, the lender has the right to sue you personally for that amount. This is the ultimate nightmare. You've already lost the house, suffered the credit damage, and gone through the emotional trauma. And now the bank comes back for more. If they win the lawsuit, and they almost always do, they get a judgment. With that judgment, they can garnish your wages, taking money directly from your paycheck before you even see it. They can levy your bank accounts, seizing whatever cash you've managed to save. This zombie debt can follow you for a decade or more. a constant drain on your ability to rebuild. Not all states allow this, and some have restrictions, but for millions of Americans, the foreclosure is not the end of the debt, but merely the beginning of a new, more aggressive phase of collections. So, is that it? Is it a life sentence? No. It is a long, arduous journey, but there is a path back. It is a path paved with discipline, patience, and humility. The first step is acceptance. The old life is gone. The goal now is not to get it back, but to build a new one on a stronger foundation. The rebuilding process starts small. It starts with that secured credit card. You use it for a small recurring bill like a Netflix subscription. You pay the bill in full on time every single month. No exceptions. You do this for a year. You might get a credit builder loan, a tiny loan designed specifically to generate a positive payment history. You create a budget, not a loose idea of a budget, but a detailed, written, zero-based budget where every single dollar has a job. You track your spending like a hawk. You cut out everything that isn't absolutely essential. Foreclosure is a brutal, but effective teacher of financial discipline. You learn the difference between a want and a need in the starkest terms possible. After a couple of years of perfect documented payment history, your credit score will begin to slowly, painfully creep upwards. The impact of the foreclosure will begin to fade. Lenders care most about your recent history. If you can show 2 or 3 years of flawless financial conduct, you start to look like a comeback story, not a lost cause. Eventually, the question of homeownership might even re-enter the picture. It's not impossible, but there are mandatory waiting periods. For an FHA loan backed by the government, you typically have to wait 3 years after the foreclosure is complete. For a conventional loan, the kind most people get, the waiting period is a full 7 years, the entire time the foreclosure is on your credit report. During that waiting period, you need to have saved a substantial down payment and have a perfect record of paying your rent and other bills. You will have to write letters of explanation. You will face higher scrutiny than any first-time homebuyer. You have to prove, beyond a shadow of a doubt, that you have been reborn financially. The foreclosure never truly disappears. It becomes a part of your story, a scar that reminds you of a battle lost. But it also reminds you of what you survived. It fundamentally changes your relationship with debt, with risk, and with the very idea of the American dream. You understand in your bones that a home is not just a place to live, but a highly leveraged, illiquid financial asset that can be lost. You learn that the only true security is a strong financial education, a healthy emergency fund, and a life lived well within your means. Defaulting on a mortgage is more than a series of legal notices and financial penalties. It's a system designed to reclaim a debt, and it operates with brutal impersonal efficiency. It strips you of your home, your credit, your savings, and your sense of stability. But what it cannot take is the lesson. For those who endure it and climb their way back, that lesson is the most valuable asset they will ever own. It's a lesson paid for at the highest possible price, a permanent reminder that in the world of finance, the foundation you build for yourself is the only one that will never crumble.